Hi, my name is Georgia Carroll and I'm continuing on with our Family Law Alphabet series with words starting with the letter O. So I'm focusing this week on the word offer of settlement or offer. So this happens in all matters, not just family law matters, but I'm going to focus specifically on how we use them during the course of a family law matter. So an offer of settlement is essentially what it says. I hate definitions like this, but it's true. It is an offer, so essentially a proposal to resolve the matter or aspects of a matter or certain issues on certain terms. So it is essentially saying, I am happy to get this matter over with if we do it like this. So it can relate to any issue in the matter, including parenting, property, child support, whatever it may be. But essentially, the purpose of it is normally to make a compromise on your open position or your otherwise stated position to either the court or that party. So when you're preparing an offer of settlement, it should always be in writing so that there's a record of it and so you can rely upon it later. It should also clearly set out the proposal, and I like to also include a time frame for acceptance if you want to put a deadline on it so that you've got some certainty and accountability in terms of making someone respond quickly and get the matter over with. Or alternatively, also confirm, this is an open, long-standing offer that I'm happy to let sit there. So there's some strategy behind which option you choose, and that's something that your lawyer will talk you through. So an offer can be both an open offer, meaning the position is something that if you're in court proceedings, for example, you're happy for the court to be aware of. So for example, my application to the court might say, I want the kids to live with me 6 nights a fortnight, and your offer may simply also say, I want the kids to live with me 6 nights a fortnight. Now that would be an open offer because you've already said that position to the court and you're more than happy for the court to know that that's what you want. Alternatively, you can also make another kind of offer called a without prejudice offer, which often says without prejudice, save as to cost or accept as to cost. What that means is that's a different kind of offer where normally you compromise beyond your open position. So for example, using that same 6 nights a fortnight open proposal with the court, I might then make an offer that says, look, I'm willing to compromise and agree to 5 nights a fortnight. And I might do that as a without prejudice offer so that the court doesn't see that offer, only the other party, and it's open for acceptance by them so as not to compromise your position before the court. So the benefit of those kinds of offers is that it keeps the dialogue going as to resolutions and as to resolving the matter on your terms. So I always say to clients, when you go to court, you're giving the resolution of your matter to someone that doesn't know you. Yes, they're an expert in the family law field and the Family Law Act and rules and so forth, and they deal with thousands and thousands of families, but they don't know your family and your kids and your situation as well as you do. So if you have the ability to essentially craft an offer and a proposal and a resolution on your terms, or a compromised resolution with both of your input, that is always better. So I love offers of settlement. You'll often send many of them throughout the course of your matter. So offers can be sent at any time as well. So they don't have to just be when you're in proceedings. There are requirements prior to commencing proceedings as part of the pre-action procedures to actually send offers before you commence property proceedings, for example. But we often send, 4, 5, 6 offers, and then you might go to mediation, and then you might go to court if you can't resolve it then. It's all about what works for your matter, but if you can try and resolve it, as I said before, on your terms, that's always a better outcome. So you can send it at any stage throughout the matter. You can send it before. There are requirements with respect to sending it as part of the pre-action procedures. And there are also during your proceedings, if you are involved in them, oftentimes when you are ordered by the court to make offers of settlement, often that will be before significant court events such as conciliation conferences or final hearings and so forth. So the court may simply say to you, I want you to put your best offer forward to the other side prior to that event occurring. Again, trying to get the parties to talk and resolve things on their own terms and see where the parameters of the dispute is. Now, lastly, I mentioned before the benefits of offers of settlement in the way that you can craft it in your own terms. And I also mentioned that you can send them on a without prejudice basis, i.e. sending them without the court being aware of what your position is, i.e. secret offers, so to speak, save as to costs. Now, the other benefit of an offer is that save as to cost aspect. So what that means is Usually the family law jurisdiction, well, it's a no cost, each party pay their own jurisdiction. However, there are exceptions to that rule. And one of the exceptions to that is if someone throughout the course of the proceedings has made an offer that is either equal to or, that the outcome of the court case is either equal to or better than that offer. So say, for example, let's use the parenting thing I spoke about before. I've made that offer of 5 nights a fortnight back in January this year, and then we have our matter determined in June, and the court says, Georgia, you can have the children 6 nights a fortnight. I might then go, hey court, look at my offer of settlement that I sent back then. I've had to incur all these costs since that time because the other party didn't accept my offer. And you've got a much better chance of the court awarding you some level of costs in the matter than you would have if you hadn't have sent that offer. So that's another benefit of sending offers of settlement, is that it preserves your cost position. No guarantees, obviously, but it's much better off, and you're much better off having sent that offer than you would have otherwise been. So lots of benefits for offers of settlement, and I always encourage my clients to send them as regularly as possible, insofar as it's practical and reasonable, and still continuing to get an outcome that is just and equitable in the matter. So stay tuned for next time. We will be talking about words commencing with the letter P.